This is bar docket number 24854 in the matter of Matthew E. Holt, respondent. Counsel, you may proceed. Just go ahead and make your announcement as you begin.
Oh, I'm sorry.
No. It's my fault for confusing you. To expedite things this morning, if you would go ahead and announce your presence, who you represent, and then begin your presentation.
Thank you, Chief Justice. May it please the court, the Office of the Disciplinary Administrator appears by Kimberly Knoll, Deputy Disciplinary Administrator. I would ask for 3 minutes rebuttal.
3 minutes is granted.
Members of the court, this is a unique situation. There was a hearing that was conducted on May 23rd, 2017, and the hearing panel felt compelled to file this motion a mere 8 days after that hearing. They didn't have the benefit of the transcript, and there is no final hearing report. The Disciplinary Administrator's Office agrees with the necessity of filing this motion. Even though we didn't file it, that's why I requested permission to appear and argue it. We believe that our office was the more appropriate body to make this argument. And we also requested that we were able to add the transcript, which will be the evidence that this court can review to determine whether or not granting of the motion for temporary suspension is appropriate. And that request was also granted. We're not asking this court to make any findings regarding the underlying allegations as to the actual discipline. There were stipulations that were made by the respondent both in writing and at the hearing. And the only issue that we're asking this court to resolve is whether, based upon those stipulations and the respondent's own sworn testimony during the hearing, whether a temporary suspension is warranted. And we believe that the court can do that by reviewing the transcript. In written form, the stipulations were a violation of KRPC 1.1 for not understanding the application deadline date format for a British passport and for failing to properly obtain the proper visa for an Australian national. The stipulations in writing for KRPC 1.3, 3.2, and 8.4D for not promptly filling out attorney registration paperwork for the state of Iowa and not completing tasks on behalf of 2 clients. The stipulation in writing for KRPC 1.5 was for keeping fees without providing a detailed billing statement and not refunding an application fee. That particular individual had to pay a second application fee for a passport because the passport process had expired, and the British government does not refund the fees. KRPC 1.16 was for abandoning the Australian national during the visa process. She actually had a visa that did not permit her to re-enter the country, and he terminated the representation when she was in the crisis. There was a stipulation to KRPC 3.4C and 8.4D for not complying with court orders in his own legal malpractice case. There was a violation or stipulation of a violation of KRPC 8.1B and Supreme Court Rule 211B for failing to file an answer to our formal complaint. There was a violation of 8.3 and Supreme Court Rule 207 for failing to report discipline from the state of Iowa. And then at the hearing, under oath, he stipulated to violating KRPC 1.4, which is communication, and 1.15, which is a trust account. And the motion indicates that he stipulated to KRPC 3.3. That was inaccurate. I actually withdrew that allegation.
It's candor to the tribunal.
Yes. And during the hearing, there were a couple of exchanges that I believe I personally was kind of taken aback, and I think is the reason that the panel felt compelled to do what they did. The first was a line of questioning regarding his activities in his own legal malpractice suit. And he had failed to file an answer in that suit. And from the transcript, Question, you were sued for malpractice, breach of fiduciary duty, and negligent misrepresentation. Is that right? Answer, yes. Did you file an answer in that case? Answer, no. Why not? Answer, I didn't know I needed to. And I responded with, again, you didn't know that you needed to file an answer to a lawsuit? And his answer was no. And then later in the hearing, there was an exchange between the panel member regarding whether or not the respondent had ever had a trust account. And the question, have you ever had a trust account since you've been practicing in Kansas associated with your Kansas office? Answer, I would guess I don't know the definition of a trust account per se. I guess that's my fault. Would somebody, and then he was cut off by the panel member who said, no, we don't need to get into that. If you don't know what it is, you haven't had one. I assume, is that fair? And his answer was, I've had a checking account for my law office with my law office's name on it. And this particular respondent is taking client money ahead of a true retainer type of situation. There was an exchange about a flat fee versus a true retainer. There was a discussion about whether or not he had read the Thurston opinion, which he indicated that he had. And there was a question whether or not he needed to change his practices, and that's what led to all of these exchanges. As of the date of the hearing, he still did not have an attorney trust account. He testified that he currently has approximately 30 current clients, and the motion was filed, I believe, because of the grave concern for the clients. There was significant mishandling of the complaints, but the testimony regarding his lack of knowledge that he could file an answer in a legal malpractice suit that led to a default judgment, that led to a $22,000 judgment against him, that led to a contempt proceeding, that led to a garnishment, and then the fact that he does have client money and it's not in trust presented grave concerns for our office, and that's why we are here asking for this court to enter an order of temporary suspension.
Do we have any questions of counsel?
Ms. Knoll, has there been any subsequent action taken by Mr. Holt? I suppose we can ask him that regarding a trust account, or do you know, in terms of his client's funds, or since the hearing?
The only interaction that our office has had with Mr. Holt was Special Investigator Delaney served him with the notice from this court as well as my supplemental requests and transcript. I've had no contact with him, and I do not know, and honestly I failed to check this morning with attorney registration.
Any further questions? Thank you, counsel. Mr. Holt?
Mr. Holt, Matthew Holt, the respondent. I guess I'm here today to discuss what Mrs. Knoll just said with the panel here, and I have made many errors in my practice, and I believe they can be rectified. On the other hand, I have, worked with many hundreds of clients over the course of my 5 years of practice. I practice primarily immigration law, assisting people with their rights in this country. And while I have made a couple of really unfortunate errors, I believe some of this has been attributed to my mental depression and also some health disabilities that I have. I've been working with my doctor in treatment the last 2 months, thanks to the KLAP program. Been taking medicine, and have been coming out from under the cloud that I've been suffering for the last 4 years of my life. And it was with much regret that I have to be here today in front of the Supreme Court of Kansas. I understand the need for the temporary suspension, and while I I can see the panel's concern and the disciplinary's concern. Looking back upon the history of my life, I believe I can rectify a lot of the issues brought here today, and I look forward to rectifying those issues in my practice. So while they call for a temporary suspension, I would ask this court to allow me to continue out my practice for the remaining days before the suspension comes down, which I'm foreseeing in the future from the court and the panel's decision.
So, excuse me, counsel, are you asking us to not impose a temporary suspension, but just let the disciplinary process proceed as it normally would?
Yes, Your Honor.
Okay, and what kind of assurances could you provide us that the types of mistakes that have occurred in the past would not occur in that period of time?
The assurances I would give is that I would, just maintain, not take any new clients currently, finish up the clients that I have currently, which are basically in immigration. I just fill out applications for the clients and make sure all the accurate information is correct and submit those to the U.S. government. And I would also provide evidence of a trust account.
Do you have one as you speak today?
I do not, Your Honor.
And why is that?
I just have not gotten one yet, Your Honor. But I can go and get one as soon as possible, because I've noticed that is a part of what I need to do too, as a part of the assurances, is to install office management skills into my practice.
Is there anybody currently assisting you in managing your law practice?
No one with a hands-on, but the KLAP people have put me in contact with some people that are going to help me, retired immigration attorneys.
All right, thank you.
Yes, that's all, Your Honors.
I think we might have a few more questions.
Oh, okay.
Justice Johnson?
Ms. Knoll mentioned a garnishment from your malpractice judgment
Yes.
against you. So has there been any seizure of your out of your law office account?
No, Your Honor. I did provide all the details and the account numbers to the attorneys, and they have did the proper paperwork where I can't touch the account any longer.
So they've frozen your law office account?
The previous one, yes, Your Honor.
And did that account contain client monies?
No, Your Honor.
Is there sufficient money in that account to cover the judgment?
No, Your Honor.
Well, where does the client money go right now? If you only have one account, don't you?
Yes.
So where does your client money go?
Well, it goes into the law firm checking account.
But isn't that the account that's subject to garnishment?
No, Your Honor.
There's a new account?
Yes.
So if I understand you correctly, in your operational account that you're currently using, does that account contain client monies,
No.
unearned fees?
No, Your Honor.
Do you have any client monies right now in any of your accounts?
No, Your Honor. In my immigration practice, I do the work for the applications, and I'm
So you're
paid after.
Your representation to us today is that all of the monies in your possession are fully earned and they belong to you or your law firm?
Yes, Your Honor.
Okay.
Any further questions? And I understood that concluded your presentation?
Yes, Your Honor.
All right, thank you, counsel.
Thank you.
You reserve 3 minutes for rebuttal.
Thank you. To follow up on Justice Stiegel, your line of questioning, the position that his money was earned was a part of the exchange at the hearing. And in the cases that formed the complaints in this case, he had taken client retainer money ahead of time, put it in his operating account. The one client, he sent a bill for 3 hours of legal work at $250 an hour, which would be $750. She paid him $1,000. He owed her $250 back. The refund check was written on his operating account. She didn't cash it because she disputed it. During the hearing, he agreed to pay her $750 plus the application fee, and to date, that has not happened. So it would be my position that minimally there should be $250 of client money that was undisputed, that was not earned, that should be sitting in some account. Secondly, the fact that he has changed his account goes to the garnishment. The court ended up holding him in contempt in order for him to turn over his financial information so they could garnish him. And it's the first that I've heard that he has now opened up a second account. Presumably they do not know about that account, so there is no garnishment going on because he has shifted his money. And that is of concern. My final concern is that his statement that he is going to timely complete the immigration clients' cases have not been proved by his conduct in all of these cases. There's significant diligence issues across the board. And so I would renew my request for temporary suspension.
What kind of timeline are we on, Ms. Knoll, in terms of right now you're asking for a temporary suspension? This matter has been submitted to the hearing panel. Those findings have been made. Do you know if this is where we're at in terms of the
I'm waiting
document?
for the final hearing report since we
So
have...
the final hearing report has not been compiled yet?
No.
That makes sense. And so once that happens, the process then would begin to be placing it before us.
Correct.
And that would be, earliest would be September, but not likely September.
I believe your docket is full in September. So I believe our first available would be October. I would presume, because I know we have some cases stacked up, that more likely it would be December.
Right.
And
So
then-
that's what I'm trying to get a
Yeah.
picture here, that if we were to grant your motion, this would be at least 6 months, probably.
I would agree with that.
Okay.
Any further presentation?
No, Your Honor.
Any more questions? I see none. Thank you, counsel.
Thank you.
We thank you both for your arguments this morning. Court will take this matter under advisement.